Welcome. Let us have a program for covering the course syllabi, the requirement of this competitive examination. Central part of this examination are statutes, the legislative domains, about 20 in number, taking our total preparation as to be of 100 number value, then we may arrange for this preparation as a program of 100 steps, 100 sessions, with our aim to cover the entire legislative domain expected from the aspirants of judicial service. We accordingly program ourselves for our preparations as being of the aim that we will cover it within 100 days, 100 sessions. Each session, as such, will be aiming at having coverage of 1% of the total expectation. In this scheme of the arrangements, today, as session 1, we are taking up the Partnership Act. It is one of the 20 legislative domains in respect of which this examination is to be there. This act is a small act. It is a specific legislation. It is about the partnership. Let us begin this session. Let us begin with prayer to the Goddess of Justice. Our prayer is that let Goddess of Justice bring us within her folds. Our prayer is an expression of our faithfulness, dedication for the cause. We are preparing, we will prepare well, and we are beginning today as session 1, and we are taking up. The session, though, aims to bring us face to face with the values and vision of this enactment, but broadly, it is also bringing us face to face with as to how these enactments, particularly the enactment and is organized, how its sections are arranged, how these sections have been grouped as chapters, how the chapters division is there. In examination, we will be provided the bare act. This enactment text will be available to us. Therefore, while preparing, we can take it as if the text as such will be available to us. Therefore, we have to visit this text from the point of view as that during examination, we can very conveniently, very easily, without loss of time, can spot the particular provision of this enactment in respect of which problem question is to be answered. Therefore, while being through this text, as has been settled by us earlier, we will be having simultaneous exercise of translation from English to Hindi, Hindi to English. Therefore, we shall have both texts in English as well as in Hindi with us. While being through this text, we can once be through the English text, then we can be through the Hindi text. This way, the text in both languages will help us to have compilation of our thoughts, arrangement of our ideas, grouping of our thoughts, and consolidation of our vision and comprehension. In the background of this, we will be perfecting our art of translation, our art of expression, and these additional values going to be acquired by us are going to be the benefits being there because of our approach of preparations. In this background, let me first of all point it out that while being through the arrangement, the enactment, we shall be very specific, we should be very clear, we should be concentrative as to what this text precisely is, how it is arranged, how it is organized. Now, Chapter 1 of Indian Partnership Act is titled as preliminary sections. There are three preliminary sections. One is short title, extent and commencement. Second is definitions. And third is application of the provisions of Act 9, 1872. One may have a pause here and take note that the Partnership Act as such originally has been part of the text of the Indian Contract Act 1872. It is subsequently that the partnership provisions have been consolidated, have been amended and consolidated as separate, as distinct enactment, Indian Partnership Act 1932. Therefore, this Act, 1932 Act, Indian Partnership Act, is at the outset, Chapter 1 itself, making it specific as to the relationship, continuity, and other connected aspects of this enactment and its provisions, vis-a-vis the earlier provisions of the Indian Contract Act. Therefore, that while being through the organization, the arrangement, this enactment, we shall be specific at the outset, as is Chapter 1 itself, making it specific as preliminary sections as to what is the title, what is the extent, what is the date of commencement, what are the definitions. Therefore, the enactment has its own definitions. This enactment is to be learned, this enactment is to be approached, this enactment is to be visited as per definitions. The Chapter 2 is the nature of the partnership. As the title suggests, This chapter, in its sections 4 to 8, is giving a definition of partnership, partner, firm, and the firm name. So, firm, firm name, partner, partnership as such become quadruple technical terms. These quadruple technical terms are to be accepted as per the definitions enactment for. We cannot make our own definitions. We have to accept the definitions as are enacted. As such, the Indian Contract Act, and its shift to Indian Partnership Act is to be conceived, is to be imbibed as per the definitions now being given in Section 4 of this Act. It is in terms of these definitions that we have to appreciate and we have to imbibe the values of the different conceptual terms and different institutional setup being created, being recognized, being given legislative sanction. The legislative sanction being given here is with respect to legal person, the legal entity. This legal entity is ownership firm, and the legal persons become the partners. Therefore, the partners, in addition to being the natural persons, now here in this reference become the legal persons. How the natural persons and legal persons are distinct personalities, and how at the same time these are the same with dual status. This distinct status of a partner from that of a natural person, which is subject of cautious attention. We have to be conscious with respect to each and every definition, with respect to each and every legislative provisions. The legislative provisions as these are, the makes a law. Law is as is legislated. Once this concept is imbibed well, once this principle is accepted, once one is of this view as that it is the law as it stands legislated, then rest of the things become much simpler. If therefore law is as it is legislated, we have to learn, we have to imbibe, we have to approach, we have to accept these provisions as law. We have to understand, we have to comprehend, we have to imbibe these legislative values. Therefore, the chapter 2, as it gives the nature of partnership, it becomes the central core, which becomes the central theme, which becomes the vision of this enactment. So these provisions, sections 4 to 8, make the central core. It makes the concept. It is the conceptual core of this enactment. We have to imbibe the nature of partnership in terms of the definitions given to partnership, partner, firm, and firm name. Therefore, our approach to this enactment is to be as per its legislative definition. A step ahead, chapter 3 is legislating the relations of partners to one another. A new institution, a new legal entity, new legal person, the form of partnership firm is being created here under. A new legal person is coming into existence. This legal person is a firm, and the constituents of the firm are the individuals designated as partners. Therefore, this legal person with a number of partners naturally will bring into the legislative domain as to the relationship of one partner with other. Therefore, the subject of this legislative domain is covering the most crucial aspect of the functional reality of the partnership forms, and accepting that, visualizing that, comprehending that, conceiving that these provisions of chapter 3 are there with us. These provisions of chapter 3, as these are focused upon the relations partners intercede. One partner and another partner are having legislative bonds. These legislative bonds are as stand legislated here in sections 9 to 17 of chapter 3. We have to be through these legislative sanctions. Each legislative sanction as it is, and having the sanction of the legislative seal, and with that becoming a binding provision of a law. So we shall imbibe these features, these values of this relationship. The relationship is legislative. The relationship is specifically coined. The relationship is specifically defined. Therefore, when we have to determine as a dispute or otherwise as to the implications of the different sanctions, different legislative sanctions of sections 9 to 17, then and only in terms of these sanctioned provisions, we have to determine justice with respect to this domain is to be as is confined, as is defined, as is framed, as is organized here in these provisions. Therefore, we have to be through these provisions with an aim, with an query, with an quest as to how the legislative comprehension resulting into legal sanctions are here in these provisions, in these sections. We cannot impose our free will. We cannot invite our common sense. We cannot superimpose and prejudice these provisions with an other thought, concept, visualization. It is only the legislative comprehension. It is only the legislative comprehension given the legal sanction here in these provisions which is to prevail. Common sense is of no use. Law is specific. The specific provisions of section 9 to 17 are to prevail when it is to be determined as to how the one partner is related, having relations, having rights, having duties, having obligations, etc., for the other partner with respect to the business and other activities and other liabilities of the partnership firm of which they are partners. So each provision is to be chewed, is to be imbibed, is to be comprehended, and comprehension is to be as is being legislated. We cannot have any artificial deviation, and once we will be through these provisions as these stand legislated, then and only then we can say that we are parallel with the law of the partnership. Step ahead in chapter 4, there is a specific provisions, specific domain, and this domain is the relations of the partners to the third parties. As in chapter 3, we have been concentrating upon the relations of the partners inter se. So here is step ahead in chapter 4. We are faced with the other distinct domain, and this domain is of relationship of the partners with the third parties. By third party, naturally would mean the party other than the partnership firm itself. So this is a very big domain. It in fact is the domain which is to bring many situations which will become the cause of disputes, which will result into litigations. These litigations are to be determined, to be adjudicated, to be settled. As the disputes would be within this domain in terms of how these stand confined as specific legislated provisions. So, when in section 18 it is specifically legislated and that each partner is agent of the firm, then we can visualize as to how the legislature is conceiving and is putting its seal, making every partner to be the agent of the firm. Once each partner becomes agent of the firm, so all activities, all relationships, all obligations, the whole range of responsibilities and liabilities, contracts, dealings, business steps will become the acts of the principal. The acts of the agent are the acts of the principal. So we can see that the legislature here is in fact making every partner's acts as far as the third parties are concerned to be taken by the third party as the acts of the firm itself. This way, we can see that these provisions of section 18 to 30 are very big, realistic coverage of the activities of the firms being conducted collectively as a firm as well as individually as its partners. So each partner being an agent in a way by his acts and conduct is going to bind the whole firm as well. It is in this background that we have to be sequentially through the sections 18 to 19 to 20 till 30, and we will have the vision, we will have the comprehension, and we will have the broader view of this legislative domain. And it is in the context of this broader domain we will be in a position to reach at the answers for the questions will arise from this domain. The answers to the questions which will arise from this domain are naturally to be answered only in terms of reasons as these are. A step ahead in chapter 5, the domain being taken up, the aspect being taken up is incoming and outgoing partners. So, see the legal entity being created, the legal person being created, the, as the partnership is being taken as that in a natural state of affairs. Some of the partners will be continuing, new partners may be entering, some partners will be outgoing. So, the domain of one person becoming a partner at a particular point of time, continuing as a partner up till another particular point of time. So, this domain between the point of entry in the firm as a partner till the point of going out of the partnership bond is not remaining as a partner. So, this partnership domain, this timeline is being taken as a specific legislative liabilities and responsibilities. So, duties, responsibilities, and other connected aspects of the partners intersee the partnership form, the partners, and the third parties in a way are being restricted, are being confined, are being specified only over acts and conduct of that timeline along which particular persons had been a partner. So it is in this particular frame we have to visit these provisions of sections 31 to 38, which make specific events of introduction of a partner, retirement of a partner, expulsion of a partner, insolvency of a partner, liability of the state, and the connected rights. Now, this again is going to be a very big legislative sanctions for the answers to the disputes and litigations which will arise and result into and which will accrue. So we have to be through these provisions, and it is only in terms of these provisions that the legal rights and liabilities of incoming and outgoing partners are going to be determined. Chapter 6 is going to cover another very big connected domain. It is dissolution of the firms. Firms or legislative creations. These legislative creations are also being made specific as to their dissolutions as well. So, creation of a form and dissolution of a form are well connected aspects. The dissolution of a form in for many inherent situations, it is a very big reality of tensions and the disputes, severe disputes, many complicated situations, many complex issues are connected with this situation of dissolution of a form. It is in respect of the partners inter se, it is also in respect of the third parties. And these provisions from 39 to 55 deserve to be visited sequentially. Each and every definition, each and every feature considered, each and every stipulation made here in these provisions have full legal implications. The justice, the litigations, resolutions, and all other aspects as are connected with the dissolution of forms are to be determined, are to be settled, are to be adjudicated only in terms of the provisions of this chapter. Chapter 7 is about the registration of the forms. The form may be registered or may be unregistered. The registered forms have different legal status. The unregistered forms have different legal status. The prominent difference is with respect to the right to litigate. Registered forms have different rights to legislate with respect to their rights, and unregistered forms have a different status altogether. It is this distinction between the legal status of the registered forms from those of unregistered forms, which is a very legal disputes domain. Unregistered forms are at much disadvantageous position, much disadvantageous platform, but still the fact is as it is, the registration is not compulsory. It is a choice, it is the discretion of the partnership forms. And the registered forms are being encouraged, are having more protections, are having different status, and we have to appreciate this distinction. And it is in respect of this distinctive feature of the registered forms from those of unregistered forms, which in many times becomes the points raised in the question papers, the examination. In this legislative domain, this aspect is a most expected domain of questions to be raised and to be answered in the examination. Finally, Chapter 8 is giving the supplemental provisions. It is about the mode of giving public notice, etc., giving clauses, followed by the schedule with respect to the maximum fee, etc., etc. Let us be through this text. Let us read this text a bit loud so that our intelligence absorbs it, so that its vision gets imprinted in our mind. Therefore, in this session, the focus is upon the Partnership Act. Thank you very much.